Hello, good morning, guys. Good morning, fabulous people. It's a wonderful Thursday morning. I'm very happy to be here. We're going to continue with the RFEs and NOIDs. We started part one and then we launched into part two. We looked at, please check out my previous videos. We talked about the 2013 policy memo and what was required of you if you were applying for any type of U.S. immigration benefit, and how reviewers or adjudicators would react to evidence that you had submitted or whether you were eligible or not. And they use the tools of RFEs and NOIDs to complete your packets for you. So please check out the previous videos on RFEs, request for evidence, and notice of intent to deny. We compared the 2013 policy memo to the 2018 policy memo, which is currently in effect. So today we're going to be looking at I think this may be the final, I don't know. If it's not, if I'm not able to exhaust it according to our time, then I would have to, do another part in order to make sure that we finish, discussing everything about RFEs and NOIDs. Guys, I hope you have your cup of tea, your mugs. We're spilling all the tea. As usual, good tea. Olamide Adibayo says, hello, Olamide. I'm happy to have you here. Thank you for always joining us. All right, guys, let me add my screen and then let's get started. Okay, so these are additional considerations. As I said, we are now in the 2018, using the 2018 policy memo. This is what the people at the United States Citizenship and Immigration Services will be taking a look at in order to in order to adjudicate your petition or to review your petition. Okay, so in some cases, particularly where the response to an RFE opens up new lines of inquiry, a follow-up RFE may be warranted. Yes, so we see this a lot. What happens is that sometimes you file an application and then the USCIS comes back with an RFE that, look, send us more information on this. We are requesting for more evidence. So so for example, there's a marriage, there's an adjustment of status, a marriage packet, and there is, you can be asked, for example, to submit evidence about the relationship. So, the birth certificates of the children, mortgages, joint taxes, and all the things. So let's say you submit a birth certificate of the children, and let's say one birth certificate was not issued contemporaneously with the birth of the child. Usually USCIS prefers birth certificates that are issued contemporaneously with the birth of the children. So for example, if the couple gave birth to their baby and let's say the baby was born in 1990, the USCIS usually prefers birth certificates that was issued in 1990, at the time of birth. If the child is, say, 15 years old and you give them a birth certificate that was issued, he was born in 1990, and you give them a birth certificate that was issued years after, maybe say in 1995 or in 2000, usually they might issue a follow-up RFE because they feel like some people fabricate these birth certificates or do it after the birth just to be consistent with the kind of facts they want to make up. So this is an example. So sometimes a response to an RFE may open up a new line of inquiry, and a follow-up RFE may be warranted. Okay, so they are telling them that, look, the officers should try as much. So remember, this policy manual is to help the officers, and we're giving you the tea, what the officers are looking out for, because this is what they're going to be using to, review your work. So it's just like we're looking at the examiner's marking scheme. So we get to see from the point of view of the examiner, and it always helps you to prepare what they're looking out for. So if possible, officers must usually include in a single RFE all the evidence that they anticipate that they're going to, have to request. So let's say, again, you're doing a marriage-based green card. The officer, shouldn't issue, oh, bring us your marriage certificate, and then send another RFE 3 weeks later and say, now bring us bring us your mortgage agreement. Then 3 weeks later send, okay, bring us affidavit from friends and family who know your relationship and know you. Usually they should try as much as possible to put everything in one request so that there's no multiple RFEs that will just frustrate the applicant or the petitioner. Okay, so usually what they do is that they have to consider all apparent gaps and then try to anticipate what they think they will need. So this only happens when they're doing a very thorough review, and then they can see that, oh, well, if you have children, bring birth certificates and bring hospital records, or bring school records showing that the father is named as the father and you, the mother, is named as the mother, or whatever, something like that. So they always have to anticipate what they will require from the client, from the applicant or the petitioner, and then request all of it at once. Okay, so guys, listen to this. In response to an RFE or a NOID, today I've actually highlighted, I hope you like it, I did green and yellow, to make parts of the text stick out. In response to an RFE or NOID, applicants, petitioners, or requesters must submit all. Yes, this is a warning, guys. So you must submit all of the requested materials together at one time. Also, not very prudent to submit, you get an RFE requesting, let's say, 5 documents. It's never prudent to just submit 2 and then 3 weeks later submit 2 and then 3 weeks later submit 1. Try to gather all those documents, all the 5 documents that you have been requested, and then submit it all together at once. And when you're doing this, normally you would have to place the original RFE or the original NOID on the top of the packet, and so that when the reviewer just picks it up, they can see that, oh, okay, this is what you requested to bring, and then it makes it really easy for them to review your packet. Okay, and usually if you do submit, if you ask to submit 5 and you submit just 2, the 2 will be deemed to be, what you're submitting, and that will be so if only some of the requested evidence is submitted, U.S.A.s will consider this to be a request for a decision on the record. Exactly. So that will be deemed to be the final submission that you are making. And so you're telling them, look, adjudicate on what I've submitted. This is all I have. I just have the 2. Okay. So additionally, failure to submit requested evidence which precludes a material line of inquiry will be grounds for denying the request. So guys, this is section 8 of the code. Okay, so this is section 8 of the Code of Federal Regulations 103. I was hoping to again pull that up, and no, it's fine. But what this is saying is that if you fail to submit requested evidence because you're trying to preclude a material line of inquiry, that will be grounds for denying the request. So sometimes you have applications and you've been asked to bring some evidence, and then you realize that if I submit this evidence, it's going to make them ask me more questions, or it's going to open up a material line of inquiry, and that is not what I want. So so for instance, you have some people who have been married, let's say 3 times, and then you're asked to submit all the divorce, your previous divorce certificates, and then one of the divorces, let's say the marriage to the third person, the divorce to the third person, the divorce was not an effective divorce, it was deficient, and you realize that if I submit this divorce decree, it will open up a new line of inquiry. They're going to find out that the divorce certificate is fake, and it's going to open a can of worms. So I'm not going to submit that. If you fail to submit requested evidence so that you're trying to preclude a material line of inquiry, that will be grounds for denying the request. I hope I've explained this with examples very well for you. So be careful of all of that when you're submitting. Just make sure you're submitting what you need to submit. Of course, again, if you need assistance with an RFE or NOID, my number is below, hit that number 8027800564. And then apart from RFEs, this is also another very interesting thing. Officers have the discretion to validate assertions or corroborate evidence and information by consulting U.S.A.s or other governmental files, systems, and database. Or they can also obtain publicly available information that's readily accessible. So what this is telling you is that it's not only what you're stating that they're going to be reviewing, they can have access to other governmental files, and they're going to check. Okay, so some people will decide to say that, I don't have any child, when they have 3 children. So they could check, if this information is available in other governmental files or systems or databases, or it's publicly available. So social media, this is readily accessible. Sometimes these things may be checked. Then you'll be in trouble. So you need to be careful of these things. Okay. It's not only what you're telling them, they also do their independent corroboration and validation of assertion. Okay, so it's all discretionary. Remember, this is all discretionary. The officer may decide to do it or may not decide to do it. Okay, yeah, so here they're giving an example that an officer could decide that, look, I want to verify the petitioner's corporate structure. They'll look at the state business website, or they may also attempt to corroborate, evidence relating to the individual's history of non-immigrant stays in the U.S. by searching a non-public U.S. government database. Okay. Yep. So, for example, the DHS database has all your non-immigrant stays. It has records of that. So sometimes they may go there using your passport number, your name, your passport number, for example, your date of birth, your first and last name, and all that, so they can get some of this information. It's available. So don't think about trying to fabricate information. And the strategy, the best legal strategy to some of these things is always to, of course, it depends. So as I say, always make sure you're consulting with your attorney, but sometimes the best strategy would be to admit and then counter, that, well, this is what happened, but here and here are these, legal explanations or legal basis. So even though this happens, section this says that so and so should not be used against me because of this and this, so there are ways to counter some of these things. So don't think it's fatal if something is not going in your favor. It's all about sometimes, facing it and explaining it or giving a legal reasoning why it should not be held against you. Okay. So these are all some of the strategies that we use out here. Let me just scroll down some more. Hopefully we should be done pretty soon. I have a number of meetings at the end of the day, so I wanted to just come your way. Okay, I think we've done this. Okay, let me share the screen right here. I took that away. Let me share it again. Guys, I hope you're having fun. I'm having a ball. Okay, good. So we're right here. There you go. Okay, so under under 8 Code of Federal Regulations 103(2)B(16)I, if a decision adverse to the applicant, petitioner, or requester is based on derogatory information and the applicant, petitioner, requester is unaware that the information is being considered, generally the officer must advise the applicant, petitioner, requester as applicable of this information, and then they have to offer you an opportunity for rebuttal before the decision is rendered. Any explanation, rebuttal, or information presented by on behalf of the applicant, petitioner must be included in the record of proceeding. Okay, so guys, this part simply means that this is where there's, the officer, the adjudicating officer, actually finds out some derogatory information, they find out any information. Derogatory information means information that goes against you or is not good, anything that weighs down on your application and gives them a reason to deny your application. It's not in your favor, derogatory. It's just bad information about you. what they need to do is they need to let you know that information, and then they need to give you the opportunity to rebut that information or the opportunity to respond. So if they find out, let's say you're applying for green card and they find out that, oh, you have some criminal records, you didn't tell them, they find that out, you know, they need to tell you that, okay, so this is what is going on, we found this out about you, what do you have to say to that? And then you'll be given an opportunity to respond to this information. It's not fair for them to just find out information and then just give a ruling or a determination on the information without giving you the opportunity to rebut, because sometimes there may be plausible explanations for some of these things. So that chance must be given to the applicant. Okay, we're almost there. Oh my gosh, well, I think this is my signal for me to end. Let me just end today's video, and then I'll just make a note of where we are at, considerations prior to issuing. So next, we'll be looking at considerations prior to issuing RFEs tomorrow, hopefully, God willing. So guys, I hope you had a wonderful day with a wonderful time with you know, all the legal tea I had to spill. If you have an RFE or a NOID and you need assistance in, you know, applying for, you know, responding to it, please call my number right there below and I'll be happy to assist you. If you're watching this video on YouTube, please don't forget to subscribe to my YouTube channel. As you can tell, I'm pretty new here, but we try to bring out videos every day and give you all the legal tea on U.S. immigration law. Call my number 8027800564. My name is Akua. I'm a U.S. licensed attorney. I focus my practice on U.S. immigration and trademark law. I am based in the DMV area, but I represent and serve clients in all 50 states and in all 19,495 cities around the United States. And it doesn't matter the type of immigration, you know, law matter that you have, I can handle it for you. Give me a call and let's schedule that initial meeting and let's see what's happening so I can assist you. My number again is down below, 8027800564. I can't wait to speak with you to assist you. All right, guys, as always, thank you for joining. Stay blessed, stay safe. And oh my gosh, there's a comment here. Randy Hioma says, salut, comment faire pour avoir visa d'immigration? Randy, I'm not sure of exactly what you're trying to ask. Est-ce que tu peux expliquer un peu, s'il te plaît? Je comprends parce que tu veux demander. Tu veux savoir quoi spécifiquement? Okay, and then we have Ajwalo who says, hello, dear. Hello, Ajwa. Thank you so much for joining. I'm really glad to have all of you on here. Guys, call my number. That's the best way to reach me. And then book a consultation with me. And then that will be my special one-on-one time with you. And then we can review your issue. And then I can help you. Okay. Stay safe, be good, and show some love. I'll see you again tomorrow. All right.